Hey, how you doing? Welcome to Man Views. Over here, I put a spotlight on all the unfairness that fathers go through. So, today's video, we have a mother that was overpaid child support. Now, let's see if the mother will be held accountable for lying on her financial affidavit, or will the judge side with the mother? Quick shout out and credit to CourtWatchers. And as always, I will leave my comments and my reaction towards the video towards the very end. Enjoy.
Versus Brandon Chilton. Today is
The court will note the appearance of Ms. Greenlee-Clore on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for repayment of overpayment of child support. I've read the pleadings, Ms. Greenlee-Clore. Is there anything else you have to add?
The only other thing I have to add, Your Honor, is looking back at the documents, the calculation, first of all, Ms. Chilton is an intelligent woman. She knows how child support works. The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. There's no way that Ms. Chilton knew, or there's no way that she did not know that child support shouldn't have been at that level that it was at. And I don't know that's not up for debate today because it's already been modified. But at this point, my client's kind of stuck where he's overpaid child support for years, essentially, to Ms. Chilton, but he has no way to get any of that child support back. And as our motion indicated, he tried to pursue this. It didn't come back. And I think what we need to do is we probably need an order from this court with how this is supposed to get paid so that if he does need to, he can pursue collection action.
Okay.
Thank you, Your Honor.
Thank you. Ms. Chilton, what's your response?
Good morning. At the time when this was calculated, as I presented to the court, I was only working part-time, and the order was based on that part-time work ending in that summer of June or whenever that school year ended. And again, as I put in my answer, that I was not going to be working over the summer because I was going to school. And then once I went back to work in August, which I did have a full-time job at that time, that is when I submitted the documentation to the child support court that I was in fact earning more money. So I did submit documentation. I didn't understate any income. We had to submit documentation to the court at that time to prove my income at that time. And so I don't feel like it is at my fault that that the child support stayed in that way. Once I submitted documentation to the court of my full-time employment, it had not changed, so I took it back to the court. I submitted it twice, as you will see in the documentation and supporting evidence that I did submit this documentation to the court twice. So I submitted, I did everything that I knew to do. I was not trying to be deceiving in any way. I submitted the information that I had, that I knew that I needed to submit. And that income was based on him working more at that time. And then he went on to a different job that caused him to make less. So the recalculation, I'm not sure where the $50,000 is coming from, but again, I was not working prior to that due to COVID. And then I started working part-time, and the child care that I was asking to be paid for at that time was not being paid for. So that's when the child support came up, because he wasn't meeting his obligation that we had agreed upon.
Okay. Well, in this particular case, I'm not going to address the issue of the amount of support because that was changed and it's already been resolved. I understand the arguments, but it would be inequitable to charge the plaintiff an amount, and again, that would, in essence, have him paying over $7,000 that he should not have had to have paid had it been calculated at that correct amount at that particular time. So the court is going to grant the motion for the repayment. Screenly Court, what I'm going to do is order that the amount of $6,891 would be repaid over the same term that it was collected. So if it was collected over, I think you said over 12 months, then that would be repaid over 12 months. If it was longer, I just don't know based upon the pleadings that are filed over what time that was collected. So I'll simply order that you can figure it out when it was collected and then have the repayment over the same term.
Your Honor, so just to clarify, dating back to the court backdated support to March of 2022. Are you saying March of 2022 to today would be the repayment period?
No, I'm saying the time that he paid the overpayment, that the repayment would be over the same term. So if it was 12 months, if it was 18 months, I don't know from the time that he began paying that $764 and the time that it changed to the 34. So it would just be repaid over the term that it was paid.
Okay, and equal monthly installments, Your Honor?
Yes.
And then no, we also made a request for attorney fees in this case. Is that
I'm not going to award attorney fees in this case.
Okay.
It sounds like there were enough issues and problems in the case to go along. I don't hold anybody responsible for that.
Okay, thank you, Your Honor.
Okay, thank you. You're free to go. You can submit that under 7 day.
Thank you.
There was a fraud.
Okay, so this is a second video.
It on the court. Plaintiff had filed a motion to set aside referee recommendation, claiming that the defendant was making more than that she had told the court. Sir, at the hearing on October 20, 2023, you could have presented any evidence you had concerning her income. Why didn't you do that?
Well, I actually sent out I sent out a subpoena for it, but I might have sent it out too late. I have a date my date of delivery was on when I got this back was on the 18th. I think that was what, two or 4 days before the actual hearing. So I sent out for the evidence, but I got it sent out a little too late, I believe. Not enough time to get it back.
Well, a couple things you could have done at the hearing. You could have asked the referee for an adjournment to be able to get that information, rather than at this point, you don't, my understanding, you don't have any information now at this point that would contradict her testimony. Is that correct?
Correct, because they still haven't sent it to me yet. I'm not.
Okay.
I sent out the like I said, I sent out the subpoena for it, but I never got the information.
Okay. Well, what the court's going to do is the court can't just speculate as to what somebody's testimony may have been. What I'm going to do, no,
Can I
you
say
can't.
something?
You don't need to, ma'am. What I'm going to do is I'm going to deny your motion, sir. If in fact you get information that in fact her testimony was incorrect, you always have a right to file a motion claiming that there was a fraud committed on the court, and the court could take that up. Likewise, you also mentioned that you are now paying for medical insurance that you hadn't before. If that's correct, send the information to Mr. Todd, and maybe at that point he would agree to modify that, taking into account or giving you a credit for that medical premium. But at this point, you don't have anything which would cause the court to, again, modify and change the referee's order. So I'm going to deny it at this particular time. But that would be the way you want to proceed if you get other information, sir.
Okay, so I have another question. As far as he backdated it to July.
He would date it to the date that the notice of, again, the modification would have occurred. That's correct.
Yeah, so that put me over $1,600 in arrears
I
already.
understand, but what happens is during that interim period of time, you weren't paying the correct amount. So that's always a risk, because we don't know if it's going to go up, if it's going to go down, et cetera. But again, the referee did exactly what he was supposed to do, is he would have modified it effective the date of the motion to modify. So he did everything correct. So again, the court's going to deny the motion, And that will conclude this matter at 10:36 a.m. You're free to go. Have a good day.
Your Honor, did you want me to prepare an order or was the court
I
going
know
to?
the court will have an order that we'll send out.
Okay, thank you, Your Honor.
Okay, thank you.
Okay, this was 2 videos in one. So let's go back to the first video, right? Let's do that. Cause these are 2 different people. Okay, for the first case, the first hearing. First of all, this mother know darn well what numbers she should have put on those financial documents. A lot of BBMs like her will do that, right? They'll put on false numbers on these financial affidavit, because you have to understand, it's you can get away with putting false numbers, even though it's committing perjury. But a lot of times, family court hardly ever, hold somebody accountable, especially the mothers, for committing, perjury. So she was fully aware the number that she wrote down was incorrect, but of course she didn't care. And a lot of time, the courtroom and also the child support department, they won't really do extra investigation to really make sure the numbers are correct. They all want to get paid, right? I mean, child support is a big business. But this mother, though, should have been held accountable. She should, her paying back, that's one thing, but she should also pay the father's attorney, because you have to understand, the fact that he had to get an attorney, pay out his pocket, just to say, hey, Your Honor, she lied. She committed perjury on legal documents. That father should have been reimbursed attorney fees from the mother. Because if it was the father that lied on that document, I promise you, he would make sure he pays back her attorney fees. So that's one thing, man. She was not really held accountable. You got caught lying. You play around with the numbers. You caused that man to, waste more money than he should have wasted. And he overpaid. He still had to take care of his, of the kid as well, and plus himself. So for those 12 months or whatever months that went by and he was overpaying, that's money that he didn't have, and he had to be behind bills. So like I said, she should have been held accountable even more, pay the attorney fees and so on. But as for his attorney, I mean, she did a decent job overall. Now let's get back to the second case we just saw. Okay, so this case right here, this guy, number one, this man should have gotten an attorney. Fellas, when it comes to child support, you want to make sure you get these numbers correct, because you have to understand, if you allow your BM to get these numbers incorrect and she get awarded incorrect numbers, that's going to hurt you in your pocket. You have to understand, it becomes hard to change that. Like right now, right, he was trying to change it, but you got to be on point, because you have to understand, when it comes to child support, everybody gets paid except for you, right? The mother will get paid, the judge will get paid, the lawyers, everyone involved in that court system will be paid. Child support is a billion-dollar industry. It's a business. It's a scam. It's a fraud. It's a business, right? It's not really for the child, right? They just use the word child support just to get away with like scamming a lot of fathers. But so you have to understand, you have to get yourself an attorney, or at least like know what to do. You can't file things late. You got to file things way in advance. So that's why it was so easy for the judge to deny his motion. Honestly, the judge could have, I've seen it where it's the mother that improperly filed something, or not in time, or don't have an attorney. I've seen the judge, low-key help out the mother out. But long story short, man, he should just got an attorney. It would have been a lot easier. But hopefully he learns lesson and get an attorney and come back. Some part of me feel on the second case, that judge just ate that father up. Like, he didn't even in no way trying to really understand the dude or hear him out properly. He was just in a rush just to kind of get him out of there. Let me watch it again. Let me make sure I'm not tripping. You know what I'm saying? Let me watch it again.
Okay, so I have a question, another question. As far as he backdated it to July.
He would
Which
date
are-
it
which-
back to the date that the notice of, again, the modification would have occurred. That's correct.
Yeah, so that put me over $1,600 in arrears
I
already.
understand, but what happens is during that interim period of time, you weren't paying the correct amount. So that's always a risk because we don't know if it's going to go up, if it's going to go down, et cetera. But again, the referee did exactly what he was supposed to do, is he would have modified it effective the date of the motion to modify. So he did everything correct. So again, the court's going to deny the motion, and that will conclude this matter at 10:36 a.m. You're free to go. Have a good day.
Wait, did he just say he'll be $1,600 behind? Holy crud. That's crazy. And look at her face. Look at her face, dog. No mercy. Fellas. By the way, there are some great moms out there. I want y'all to feel like, that I'm not, there are some good moms out there. But, we put the spotlight on the greedy moms right now. Look at her face. Wow. But yeah, this dude, listen, I've seen cases where the judge is very lenient. Very lenient towards, the mother when it's her on the other end with stuff like this. He's just extra harsh on the dude. But nevertheless, though, fellas, here's my quick advice to y'all. When you, as a father, as the man, when you go to these kind of court hearings, whether it's for family, child custody, or child support, listen, you either, number one, if you can afford, get an attorney, or if not, get like a legal aid or free attorney. But if not, if you go pro se, you have to come with extra exhibits, extra evidence. The more, the better. Have more than you actually need. You have to understand, with a mother can just go to the courtroom and without no evidence just speak, and the judge can believe her or feel sorry for her or feel bad, and then she get her way. But for you as a father, it doesn't work for you. Your words doesn't mean nothing. You have to bring evidence, document everything. In his case, he should have, I don't know the prior case that he was involved in, but he should have just fought harder, like, nah, she's lying, Your Honor. Or how does that make sense if she's saying she's making this amount, but then she living in this house and driving that kind of car? Like, say whatever you can that will question her numbers. Yeah, you gotta walk in with some kind of evidence. Fellas, you can't just walk in without no evidence. But that's my advice to y'all. Document. Don't walk in with just no evidence. It's just, the more the better. The sooner you get the evidence in, the better. If you can't afford an attorney, get it. If it costs, listen, I'd rather you paid for an attorney regarding child support hearings or cases, because if you go there by yourself and you don't know what to do, don't know how to do it, you'll end up paying more in child support than you would paying for that attorney. Spend that bread if you got it. If it's like, if I want for like $2,000 attorney, you know what I'm saying, just get them. It'll be better than you doing it yourself, unless you know what to do. But anyway, what's your thoughts about this entire thing? This was a very weird video, right? But and this goes out to all y'all love BBMs out there. Listen to me, man. Stop lying on these documents. And judges, man, let's start holding these moms accountable for lying. Because once you lie on financial affidavits, you are literally committing perjury. Literally. You should, but like I said, they hardly get held accountable. But yeah, I mean, fellas, once you see your BM lied on that financial affidavit, get an attorney and be like, hey, she lied, and put pressure on the judge to hold her accountable for lying on those legal documents. The only time, most of the time where someone really be held at perjury is when it's like, regarding a criminal case or murder case. They take that very much more serious, which I get. But still, man, this is somebody's livelihood. You mess somebody's money and saying the wrong amount on the paper, just so you can get paid more money. You should be. Look, I think you should go to jail. That's what I believe, for lying on it, and then pay back everything that you received from that father. But these are my thoughts. What's your thoughts? Comment below. Let me know what you thought about the video. Was the judge fair? Was he unfair? Was he biased? Was the father's attorney on the first hearing did good? Did she, did bad? As always, don't forget to like, subscribe, and comment your thoughts below. Thanks for watching the video, and I'm gonna catch y'all next time. Don't forget, parents, put the child first. Don't hate your ex more than you love the child. See y'all next time.